Good afternoon. My name is Hae-sun Kim, advisor of Gangnam Labor Law Firm. Today with Labor Attorney Jung Bong-soo, we will cover the Article 5 of the Labor Union Act. So the Article 5 of Labor Union Act is the organization and membership of labor union. So could you explain the terminology first?
Yes. Hello. How are you today? This is Bong-soo Jung, Korean labor attorney. According to Article 5, workers they are free to make a labor union. Also, they can become a member of such a labor union. So, in this process, like any employee, they can join labor union. But those people who are working for the employer directly, also those people working in human resource team or some account team, they are not allowed to work. They are not allowed to join labor union. So it is very important that labor union must have their workers. I mean union members from workers, excluding the general manager or those people working on behalf of the employer or working for the interest of the employer. Then such a union that includes such a people, then such a union cannot be regarded as a union because they easily lose their independent management. So yeah, so only those people who work as an employee without such a authority, then they can join a labor union and they work as a member of a union. Yeah.
Okay. So can you explain about the key benefit for the workers between having the labor union and the one without the labor union? What would be the key benefit of forming the labor union?
Yeah, it's a good question whether a labor union is necessary or not in the workplace. So of course, in the company's perspective, they don't like to have a labor union in their workplace because if there is a labor union, employer always talk to or ask some opinion. Also, they change rules, then they need to have some consultation or must have an agreement with the labor union. So, employer, they want to make their decision and implement it immediately. But when there is a labor union, it will take a second idea or second thought. That means they must talk with the labor union first. So, but I think employees' perspective, it is really good because if employer make a unilateral decision, also they make an unfavorable decision, then workers cannot ask or cannot claim individually. So labor union can be a good protection tool to protect their job security. Also, they can ask for improvement of their working conditions. So, workers' perspective, labor union is necessary.
I see. So, can you explain the difference between the representative of labor union and the representative for the collective agreement? Can it be the same person or they can elect a different person for this?
Oh yeah, of course. Yeah, I mean representative. Usually, union chairman we call it. They are those union chairmen must be selected by the pro and con vote. So also they must have a majority vote. Then they can be elected as the chairman of the labor union. So employee representative, maybe usually those people who received some the kind of autonomy. They like labor union chairman give authority for collective bargaining to particular person. Then the person can be a representative of a labor union. So union chairman and representative of a labor union is they can be the same person, but based on their function, it can be a different. Yeah.
I see. So in case of because Gangnam Labor Law Firm provide a number of service to labor law service to foreign direct investment companies, many large corporations who were acquired by foreign company may have the existing labor union, but those new companies, foreign companies, may not have this labor union. So it will be beneficial to have our service to guide them about the labor union. Is that right?
Yeah. So there is some company that they don't want to have a labor union. So such a company can be POSCO or Samsung, the group companies. But by law, it is illegal if they intentionally prohibit the labor union to be established. So I think labor union is protected by the Labor Union Act. Also, Labor Union Act is originated from Constitution. So we can say the right to make labor union is a kind of people's the basic right protected by the Constitution. So in Korea, I think I can find some competition between non-union company and union company. So if there is a labor union, their working condition is relatively higher than the company that doesn't have a labor union. So in this, in my opinion, labor union is necessary to protect the workers' right, especially foreign companies. So foreign companies, they invest their money and their technology, and they built up their own factory or service center. So their purpose is to make their profit and continuously earn the money here. Maybe secondary, they contribute to the employment or contribute to the social community here, but their first purpose is to make their own profit. So without profit, they usually withdraw from their operation in Korea. So to protect workers' rights, usually the foreign invested companies, labor union is easily composed, and they ask for collective bargaining for better working condition. Yeah.
I see. So while we go through the Labor Union Act, I hope that many companies here, especially the foreign companies, can benefit from the forming the labor union based on Gangnam Labor Law Firm advice.
Okay, thank you for your comment. Okay, bye bye.